back there? We'll find out when we open the curtains. It's a beautiful thing when it works the way it's supposed to. And this is the case of Vallandingham versus SRMOF, which we'll just call Lender, I think, for ease. We'll call them Lender. Is that okay with you?
You can call them Lender, you can call them SRMOF. Smurf, doesn't matter.
Smurf, I like that. All right. You may proceed, sir.
May it please the court. I'm Mark Stopa, counsel for the appellants. I'd like to begin by thanking the court for moving the oral argument to today. I had another oral argument on Tuesday before the second district. I would have been in a lurch. I appreciate that, especially since I know you're going late this morning. I have an issue of first impression before the court, and before I explain why I think you should write an opinion in my favor on that issue, I'm going to start with a couple of propositions that I think everyone will agree with. The first is, when this is an FHA mortgage, the plain language of paragraph 6 of the note and paragraph 9 of the mortgage required that this lender comply with regulations of the Secretary of Housing and Urban Development before accelerating and before foreclosing.
All right, so the main objection you have is that the letters were not sent certified. So,
Well, that's part of it, and that was going to be one of the two propositions that I start with by saying I think everyone will agree. I think everyone will agree.
you didn't have your clients there for what was deemed to be a strategic reason, so there was no evidence that they didn't receive the letters about the face-to-face meeting, correct?
Okay. There was no evidence they did not receive the letters. I agree with that, but that's simply not pertinent to the analysis that we have. The issue that everyone should agree with, and I don't think my opponent even disagrees with in the brief, is that the evidence that was adduced at trial did not show compliance with the HUD regulation that this appeal is predicated on, because it was undisputed that no counseling was done. The bank's own witness testified that the counseling wasn't done. Now, there are 5 enumerated exceptions under the regulation to that counseling being done.
Send them a letter saying, we'll meet and have a face-to-face, and they don't respond.
They actually sent 5 letters, I think.
So they're supposed to go and beg them? Is that what you suggest?
Well, Your Honors, I respectfully submit that the sending of letters is not one of the exceptions under the regulation. One of the exceptions under the regulation is to make a reasonable effort to do the counseling, and the reasonable effort is defined as sending a letter by certified mail and making a trip to see the mortgagor at the mortgage property. So are they supposed to beg? No, but they're supposed to do what the regulation says, which is send by certified mail and make a trip to see the mortgagor at the mortgage property. It's undisputed on the record before this court that that didn't happen. There was no evidence that that happened. There was no evidence that the counseling was done, and there was no evidence that any of the 5 exceptions applied. The regulation could have been drafted.
Assuming that there's a violation, what prejudice is shown by your clients?
Well, Judge, respectfully, prejudice is not an element when you have a compliance with a statutory condition precedent.
Have you read our cases on conditions precedent?
Certainly, but those are contractual conditions precedent. I cite the Stresscon case out of the Florida Supreme Court. The holding of that case is that where you have a statutory condition precedent, prejudice is not an element in the analysis. And there's also a 4th District case that I cite called Lamberti that follows that. That is the law with respect to statutory conditions precedent. And those cases provide you don't get to legislate from the bench by rewriting statutes, because if the legislature wanted prejudice to be an element in the statutes, they would have put them in there. They didn't. My opponent does not even argue otherwise in the briefs. So the prejudice or absence of prejudice based on the counseling being done or not being done is simply not a consideration before the court.
Did you all take the position that this was an affirmative defense?
No, Judge.
You never said that. At no point below are you suggesting that this record is devoid of reference to this as a defense?
The term defense was used colloquially.
You call it colloquially. I'm sure that I view it that way.
Well, Judge, with all due respect, the issue was pled as a condition precedent and litigated as such under rule.
You didn't plead at all. You just had a general denial that conditions precedent had been,
Not at all, Your Honor. In what paragraph under 1.120C, it was compliance with conditions precedent was alleged generally in the complaint, and in the answer, we specifically denied and pointed to this specific regulation, specifically cited this regulation in that answer in the corresponding paragraph of the answer where the plaintiff denied alleged conditions precedent. So we specifically denied it in our answer, and then at trial, the parties litigated it as a condition precedent. Why? Because in the plaintiff's prima facie case, they introduced or tried to introduce evidence pertaining to this regulation. They elicited testimony about the face-to-face counseling not having been done. They introduced these letters. The only purpose of the letters was with respect to this counseling issue. This was both pled and litigated as a condition precedent.
So you're saying if it's I think your argument is that it's a condition precedent, right?
Absolutely, Your Honors. And
If that's the case, and we just talked briefly about some of our cases that say that if it's a condition precedent, there may be substantial compliance, and so that would get you to satisfaction of the condition preceding. You saying that doesn't apply to this?
absolutely does not apply. Those are I'm familiar with Gorel and Vasilevsky and all those cases that from this court that talk about substantial compliance with a contractual condition precedent. You don't get to employ that analysis with a statutory condition precedent. That is Stresscon, the Florida Supreme Court case. That specifically holds that. You can't have substantial compliance with a statutory condition precedent because what that puts you in the position of doing is rewriting the statute. It's the legislature's prerogative to write the statute. It's the court's prerogative to enforce the statute as it's drafted. So that argument that my opponent made in the briefs, well, we came close enough, we substantially complied, that's wrong. If Congress wanted the mere sending of a letter or 5 letters, or doesn't matter how many letters, if they wanted a letter to be an exception to giving the counseling,
in this particular case, if the letter was sent in accordance with the regulation, but it just wasn't sent certified mail, but it was established that they received it anyway, that the fact that it wasn't sent certified mail would be sufficient to say that the condition preceding wasn't complied with?
yes, but there's more than that, Judge, because now the mere sending of a letter is not sufficient under the regulation. They had to send a letter and...
Okay, hold on. I'm just trying to get your position here and understand what you're... So in other words, you say the substantial compliance doctrine really doesn't apply to a condition preceding that's established by statute. So my question to you is, let's just assume, for purposes of argument, that there's a case where the letter was sent in strict compliance with the regulation, except the regulation required it be sent certified mail, and it wasn't sent certified mail, it was sent regular mail, but there's no dispute that they got the letter anyway. You're saying that that the fact that it was not sent by certified mail, but they received it anyway, that would be sufficient for the court to say they did not comply with the condition preceding?
Yes, because the sending of certified mail is not an exception. They have to not only send the letter, but they have to make a trip to see the mortgagor at the mortgage property in addition to that. That is what the regulation defines as a reasonable effort.
Let's assume they did that too. They sent the letter, and then they had their meeting, and they went and all of that, and then all of a sudden, the foreclosure suit's filed and said, okay, well, we received the letter, and we went, and we had our meeting and all of that, but you didn't send it certified, so therefore that, you didn't comply with the condition preceding, so you're out of luck.
I mean, that's certainly a closer call, but on the facts you have here, not only was there no trip to see the mortgagor at their mortgage property, no evidence of that, but in addition, the letters were not sent in the time.
Now, what I'm trying to get at, you say that's a closer call. Does that mean that there may be some instances where substantial compliance would suffice and maybe other instances where it wouldn't?
I don't see how you have a substantial compliance analysis here. The reason I said it's a closer call is because there's not any, obviously it's a closer call factually, there's not any case law on point to address your hypothetical at all, anywhere in the country, okay? If the letter was sent, it admitted received, but not sent certified, and that was the only
One more. So in other words, if it's the regulation and it's a statute, that every specific point must be complied with. Every specific point must be complied with to the letter.
I believe that's the law when you have a statute like this. I would encourage you to look at the Massachusetts case that came out on this regulation that I did a notice of supplemental authority on, just came out a couple months ago. The counseling was actually done in that case, but it was done 2 weeks after the regulation provides, and this was the next point I wanted to make. Even if these letters had been sent, they weren't sent when the regulation says they're supposed to, because the counseling had to be done, quote, before 3 monthly installments are unpaid. Here, the evidence showed that the first letter was dated a month and a half after the third monthly installment would have been due. What did that Massachusetts case say? Even when it was only a couple days after that third monthly installment, they still said that's not what the regulation requires. So yes, they were holding it to the plain language of the regulation, and here,
Mr. Stoppa, drink decaf before you come back. Slow down, slow down.
Or take some sort of medication.
Yeah, just drink decaf, it's okay.
I have a lot I'm trying to get to that I haven't even been able to start
Let me
yet.
ask you
We
about that.
actually do read the briefs.
Let me ask you about the Massachusetts case.
Sure.
Just on that last point about the letters being beyond the 3-month date, didn't the court also say if that's all we had, that wouldn't be a problem?
I agree with that.
I think that's, but what they said there was, and I didn't realize that they offered counseling at Gillette Stadium, but is that
Sure.
where the Patriots play or something?
It is. It's not directly on point, but okay, but
But, in any event, I think that your point is that there's 3 problems here. The letters were untimely, they weren't certified, and that the bank never went to the property.
right. And the point being that the evidence at trial did not show compliance with the regulation, okay? And every state in the country in the last 35 years, including Florida, that's ruled on this issue, has ruled you have to comply with the regulation when you have an FHA mortgage, okay? So that leaves the dispositive point before this court of, is compliance with a HUD regulation in an FHA mortgage a condition precedent or an affirmative defense? I submit that it is and has to be a condition precedent and not an affirmative defense for a variety of reasons.
Well, we've treated in Fannie Mae mortgages, we've certainly treated paragraph 22, 30-day notices as conditions precedent. And I can't think of a good reason as to why this would be different, but I'm waiting to hear your opposing counsel give me that good reason. I'm sure he'll try.
Thank you. I love the way that you said that. That's exactly the way that I see it. I noted in the reply, I explained in the initial brief, I made that comparison between paragraph 22 and FHA. If it's a condition precedent in paragraph 22.
Of course, we also did utilize a substantial compliance analysis, and that was a statutory requirement, was it not?
No, paragraph 22 was a contractual condition precedent spelled out in the contract, just as this note and mortgage requires in the contract that the compliance be with the HUD regulation. So that's...
So let me make sure I understand now. I think there were at least 4 or 5 letters that were sent saying, let's meet and let's get together. And they were sent, they weren't sent certified though. They were just mailed, and the bank wanted to meet with the borrower and try and work it out. Did the borrower, is there anything in the record to indicate that the borrower ever replied to those letters and said, okay, let's meet, here's the time and here's the place and that sort of thing?
Not at all. Now, the inaction or the lack of a response or the lack of evidence about a response is on them. That's not on us. Now, they tried to characterize it in their brief as, well, we made a clear intention to not want to participate, a clear indication we didn't want to participate. You can't do that by inaction. If the Congress intended for that to be the case, they would have, again, allowed the mere sending of the letter.
Well, if they didn't, I mean, if your clients didn't reply to 5 requests for a face-to-face meeting, what would make anyone reasonably think that they would have done that with a letter sent before that was sent certified?
Well, with all due respect, the way you're writing out the portion of the regulation that requires the trip to see the mortgage or at the mortgage property. Congress thinks it's important enough for the lender to go knock on the door and make sure someone's there and talk to them and do it in person, face to face. Because you don't know if the letters were received. You don't know if they got them. You don't know if the mail was intercepted. There can be any number of explanations that are not a clear indication that we don't want to participate. For instance, there could have been proof of a telephone call where my client said, yeah, we don't want to do this, we're not interested. That would be a clear indication we don't want to participate. This record is completely barren on that point. I want to go back to my paragraph 22 comparison, because it's more, paragraph 22 in the Fannie Mae mortgage, it requires as a condition precedent to acceleration and foreclosure. Clearly a condition precedent, clearly part of the plaintiff's prima facie case. And what is that based on? It's based on a contract where the mortgage right to accelerate and foreclose has the same paragraph of the obligation to send the letter, right? The right to foreclose, the default remedies are in paragraph 22. That's what gives the lender the right to accelerate and foreclose. You don't get to accelerate and foreclose unless you've sent the letter. These FHA mortgages are set up the exact same way. Paragraph 9 of the mortgage gives the right to foreclose and accelerate and foreclose upon a non-payment. That same paragraph requires that the HUD regulations be complied with. This security instrument does not authorize acceleration or foreclosure if not permitted by regulations of the Secretary. I argued that in detail in the initial brief. They had no explanation for that in their answer brief. They totally ignored the issue. There is no good reason to treat paragraph 22 as a condition precedent, as this court and every other DCA does, and to treat it as an affirmative defense in FHA. That's why all the states that have ruled on this have ruled that it is a condition precedent. New York in the Teed case, Massachusetts in that
Okay,
Cook case.
The regulation says that the letter has to be sent within what amount of time? 30?
Before 3 monthly installments due on the mortgage are unpaid. So January 2011, default, they had to send it before,
Repeat it again now. What did you say?
before 3 monthly installments due or unpaid.
Or 3 monthly installments.
Right. So it was a January 1st, 2011 default.
So what if it was, before maybe 4 monthly installments were due? And instead of serving the letter, sending the letter certified mail, that they had a process server go out there and serve them with the letter?
Well, if they make a trip to see the mortgagor at the mortgage property and the process server is an agent of the lender.
I assume they did that too, but they didn't send it certified, and they didn't strictly meet the time requirements.
Well, not strictly meeting the time requirements is the Massachusetts case that I cited in the supplemental authority.
Well,
That would be- that
but
would be
even
enough.
that case, and I'm looking at it, it says untimeliness alone is not dispositive of the summary judgment question. They said, we're not, at least my reading of that case is, if that's all there was, that probably wouldn't preclude foreclosure. They
It sounds
found-
like a substantial compliance analysis.
Well, but here I don't think that Florida can do that under the stress gun case, but here you have the untimeliness and not certified and not making a trip to see the mortgagor at the mortgage property.
Counsel, you're down to 3.5 minutes.
And I appreciate you noting that. I'll save the rest for rebuttal.
Thank you.
Thank you, Your Honors.
Morning, Your Honors. Franklin Cosman on behalf of the appellee.
Counsel, is it your contention that your client complied with the FHA regulation?
Your Honor, before we get to that, I think that the issue is that whether or not this is an affirmative defense or a condition precedent.
Well, all right,
But if you want me to answer the question, I will.
no, that's fine. Tell me why we ought to treat this, we've consistently treated paragraph 22 in Fannie Mae mortgages as conditions precedent.
Absolutely, Your Honor.
Why would we treat this differently? And I think you can make principled arguments that it could be a condition precedent and it can be an affirmative defense, but just for the sake of consistency, why would we treat it differently than we have paragraph 22 in the Fannie Mae's?
Paragraph 22s in a standard mortgage are contractual condition precedent. It sets out specifically what needs to be included in the default letters. The amount of the default, the date of the default, what needs to be done in order to cure the default, how many days you have to cure the default. That is all set out in the mortgage on what needs to be included in the letter. The mortgage and note here are not as specific. It says that the lender's right to foreclose may be impaired because of the HUD regulations, but it doesn't specifically set out what the HUD regulations are. It doesn't even set out specifically the part of the CFR where the regulations are contained.
Well, but you're not contending your client didn't know the regs.
No, not at all, Your Honor, but what I'm saying is that that was a contractual condition precedent This is not a contractual condition proceeding because the contract isn't clear as to what the regulations are. Contrary to what opposing counsel has said, the word defense wasn't used colloquially. It was used throughout the trial, that it was a defense that was raised 5 or 6 times. Additionally,
So your argument is that this ought to be an affirmative defense, which would place the burden to prove that you didn't comply, and their argument is it ought to be a condition preceding.
exactly, Your Honor.
Okay.
Now,
Well, see, that's not how I'm hearing that. It almost sounds to me like you're saying that they didn't preserve this issue.
that the appellants didn't preserve the issue? Your Honor, I think that when it comes to the issue preservation, that they're claiming that there was a failure to comply with the condition proceeding.
Well, you're suggesting, and I think you do this in your brief, that they took a different position below than they're taking on appeal.
I do, Your Honor, and the reason is,
And that's a preservation issue, is it not?
yes, Your Honor, I think you could characterize it that way. I think that because,
Would you characterize it that way?
absolutely, Your Honor, because they use the words defense, they cite cases, the Knight case, the Lacey case, where they talk about violations of the HUD regulations as being defenses, not conditions proceeding, but defenses. At least 4 or 5 times at trial, Your Honor, several other times in their brief, over a dozen times, they talk about the defenses. And you can't, when it's a term of art, you know, we're not, I made a mistake as a young lawyer where I asked somebody for an extension of time to answer a complaint, and meaning answer with a lowercase a and not an uppercase A. The other side took it as a term of art that I was going to answer the complaint. Here it's the same thing. They're using a term of art that it's a defense. And there's a difference between a defense and the burden of proof and a condition proceeding and the burden of proof. So here, when they're, and the trial judge even said the same thing on page 187 of the record, that they failed to prove the conditions proceeding. So in this particular instance, they tried this.
Failed to prove the conditions proceeding, or failed to prove the...
I'm sorry, Your Honor, my mistake. They failed to prove the affirmative defense. So in this particular case, they try it, they use the terms, a defense to the foreclosures, they cite cases, they give cases.
The regulation says that you shall do these things before you can declare a default.
Your Honor,
Doesn't it seem to indicate that it's a condition preceding?
Your Honor, the regulation doesn't say this shall be done prior to a foreclosure. It says that you'll have a face-to-face meeting. It doesn't say that you are precluded from foreclosing if you don't do this. That's not what the regulation says.
I thought the note said, this note does not authorize acceleration when not permitted by HUD regulations. And then, so you got to go look at the HUD regulations, and the HUD regulations said, you got to do this, this, and this before you can foreclose.
Yeah, isn't that what it said? That regulation says before you can declare a default, and you can't foreclose until you declare a default, right? So doesn't that mean, wouldn't that indicate it's a condition preceding? Let's set aside what they labeled it and what you labeled it and what was argued below. Let's just look at the regulation and see what from the regulation can we glean that would indicate that it's either an affirmative defense or a condition preceding. So my question to you is, wouldn't that language in the regulation indicate it's a condition preceding?
Your Honor, I would disagree that it's a condition proceeding because it does, the regulation itself doesn't bar foreclosure. It tells you that you have to do these things, and the note and mortgage say you can't do it until you comply with these things. And getting back to Judge Orfinger's question earlier, is that there was a substantial compliance. That we sent a default letter on March 3rd. The first contact by letter.
How would you respond to his argument that there's a difference between contractual and statutory analysis for purposes of substantial compliance, and that under Florida law, if it's a statutory noncompliance, you don't use a substantial compliance analysis?
Well, Your Honor, I think that when, in this particular action, it's almost like a hybrid because...
The case law that what I'm asking you to respond to.
Yes, Your Honor. That in this particular instance, the case law doesn't squarely fit. It's a square peg into a round hole, that you've got a contract that has specific provisions in the note and mortgage, and then you have the regulations that are separate. At one point during opposing counsel's initial comments, he talked about it being a contractual condition proceeding. He also talked about it being a statutory condition proceeding. So I think that it's,
Well, why wouldn't it be a contractual condition preceding if the contract, if the note and the mortgage say that you'd have to comply with the regulations?
that's exactly my point, Your Honor, is that the contract between the parties themselves, the note and the mortgage, require these things.
And maybe if the regulation applied without, any contractual provisions that say they applied, but, I guess my question to you will also be if they don't apply unless the contract says they do, and then the contract says they do, why would that be a contractual condition preceding as opposed to a statutory or regulatory condition preceding? So you want to finish answering that?
Your Honor, I think that you're correct that it is a contractual condition proceeding because the note and mortgage entered into between the parties have that obligation.
Would this regulation have applied without the provision in the contract, or when I say contract, the note and the mortgage? Would this regulation have applied without that provision in the note and mortgage saying that they apply?
Not at all, Your Honor, because the parties wouldn't have agreed to it. If it's not in the note and mortgage and the parties, that's the binding agreement between the parties, so it's not there, it wouldn't apply.
Yes, your position is that it's a condition preceding because the two parties agreed it would be a condition preceding, the condition preceding would be what is contained in the regulation. All right.
Well, Your Honor, I'm sorry, can you rephrase your question?
In other words, I think what you're saying is that it's a contractual condition preceding because the parties agreed it would be a provision of the contract that they complied with the regulations.
Well, first of all, Your Honor, I'm not conceding that it's a condition proceeding, but if it were to be considered a condition proceeding,
You're saying
that would be
it would be
contractual.
contractual.
That in this particular instance, the case law, all of the
Do you
case
agree
law.
that there's case law out there, as opposing counsel indicated, that says that there is that distinction between contractual and statutory, and that the statutory requires strict compliance and there's no substantial compliance?
Your Honor, I think that, strict compliance does not mean that every single I needs to be dotted and every T needs to be crossed. So, using some of your examples.
Let me phrase the question another way. Do you agree with opposing counsel's rendition of this state of Florida law that the Florida Supreme Court has ruled that if it's a statutory condition preceding, substantial compliance doesn't apply?
I would agree with that very sterile hypothetical. But I do think, Judge, that some courts have found that if you're off by a day or two, that it is an insignificant noncompliance.
Well, let's
So-
figure out, so if we're going to look at substantial compliance / prejudice, the regs say that you've got to send a certified letter, and I understand my looking at the record says that you sent 5 letters, none of them certified, other than the acceleration letter was sent certified, but the letters offering face counseling were sent ordinary mail. There were 5 of them, but you concede that none of those were sent certified, and you concede also that there was no visit to the property.
I will concede that the record doesn't reflect that those were sent certified, and I will concede that the record doesn't reflect that there was that somebody went to the house. But the first letter also asked for them to call them to set up a counseling session. The first letter, the March 3rd letter, Your Honor, I think in the very beginning, asks them to call them. It doesn't say for a face-to-face, but it says to call us so we can help you save your home. So, the letters, many letters were sent, none of which were responded to. The Vallandinghams didn't respond to anything. One of the exceptions to making the face-to-faces that, they clearly indicated that they won't cooperate with an interview. They received a certified letter that was sent on March 3rd. They received 5 letters afterwards, 7 letters, because there were 2 letters with the March 3rd. Not one of them was responded to. The bank, I think that a reasonable person would think that after all that correspondence, nobody would cooperate with doing a face-to-face meeting to try and work out this matter. One of the other things I wanted to point out, which we also briefed, is that this matter comes to this court with a presumption of correctness. The trial judge understood the case to be tried based on an affirmative defense, that the affirmative defense wasn't proven. And that's on the record on page 188.
Okay. Counsel, thank you.
Thank you, Your Honor.
Hold on just a minute here. You've got about 3 minutes
Let me,
remaining.
while because your time is limited, I do want to get to my question about whether this is, let's assume that we say it's a condition preceding. Then is it a contractual condition preceding or is it a statutory? And would you agree that this regulation would not apply unless the note and mortgage says it applies?
No, I don't. This is an,
It applies anyway. It applies
Yes.
to every mortgage.
this is an, no, not every mortgage. This is an FHA mortgage. And because this is an FHA mortgage, the HUD regulations apply as a matter of law. The contract just duplicates that by requiring compliance with those HUD regulations before accelerating and before foreclosing.
Do you disagree with opposing counsel's?
Absolutely. And I think the,
Counsel, let me ask you, and again, you got a limited amount of time, and I know you got a lot to say, but let me just ask you, you cite both the Laws case, or maybe opposing counsel does, but somebody cites the Laws case and the Knight case, and both of those courts say the failure to comply with FHA regulations is a valid defense to foreclosure. How do you address those cases and the idea that it's a condition preceding?
couple ways, Judge. First, those are both summary judgment cases, and in the summary judgment context, the burden of proof is always on the movant. Here, this is a trial. Those courts did not address whether, who bore the burden of proof at trial. So, and also, the Knight case emanated from a case called Cross out of the 4th DCA from the late 70s. I cited all the cases in my brief that show how that line of cases is no longer the law anymore, because since the late 70s, this HUD regulation was codified into law by Congress and exists in the party's contract now. So where it was just an equitable defense previously, when it wasn't codified into law as part of the contract, it is actually law now.
All right,
And
let me ask you, all right, I'm with you. So let me ask you about the one letter that was sent certified, the March 3rd letter. It starts off, you're going through tough times, you may be eligible for a workout, you must call us immediately, the longer you delay, the fewer options you've got. You've got time to cure the default. We need to talk to you to discuss your options. Why isn't that letter enough? I agree the face-to-face, going to the property is a separate issue, but why isn't that letter enough that was sent certified to constitute the compliance with the requirement that there be a certified letter?
because it doesn't say anything about HUD counseling. It doesn't say anything about a face-to-face interview. It doesn't say we want to have a face-to-face interview with you. We want to try to work this out via a face-to-face interview. That's what the regulation requires. What they're asking you to do is rewrite the government regulation. I ask you to take a look at the cases that I cite about why this has to be the law. Okay, and there are other jurisdictions, because Florida hasn't addressed these, but why does this have to be the law? This was a risk-free loan. They get the benefit of government insurance. If they get the benefit of government insurance, they have to do what the government says in order to get that. And there are cases that have held that. In addition, this is a loan to low-income housing individuals. Before you're going to foreclose on low-income housing homeowners, you should have to do this regulation. There's lots of cases that employ that policy.
Counsel, you've exhausted your time.
Thank you, Your Honor.
Thank you both very much.
Are you driving, you're from Tampa, is that right?
I am, Your
Are you
Honor.
driving back?
I am.
Drive slowly.
I'll try, Jeff. Thank you.
All right, thank you both.